Well, hello, everybody. It has been a few months. I'm really happy to be back here with Bike Talk number 5. I hope that I always like to check at the beginning to make sure that we are visible. Let me take a look. We are. Okay. Feel free to post a comment. Let me know that you're out there. We'll entertain questions throughout this video presentation. Just a little bit of introduction. This is our 5th bike talk. We covered a lot of other topics on the 1 through 4. They're available in video, and they're on the Facebook page, but if you can't find them, let me know. I'm Ann Groninger. I'm with Bike Law North Carolina, and as of April 2021, also Bike Law Utah. Most of you I know that are on here, and you probably know that I represent bicyclists who are injured in car wrecks usually, or sometimes other strange things that happen on the road. We have a lot of stories. Now, North Carolina, hi Bike Maryland, North Carolina and Utah are both part of the Bike Law Network. The goal of this network is to advocate for bicyclists, both in the community and throughout the legal system, and to pursue bicycling justice. Now, we are located in a number of states, and if you want to find out whether your state is a part of Bike Law, you can go to the bikelaw.com website, scroll down to the map, and see whether your state is highlighted. If you're not, and you are looking for a lawyer in your state or Bike Law help in your state, feel free to contact our general number, and our Bike Law headquarters will help you out. Hello, everybody. I see some people chiming in there. Stephen, John Bookie, nice to see you all tonight. All right, well, so tonight we are going to talk about the criminal justice system. Why are we going to talk about the criminal justice system? Well, there are lots of reasons. And one, of course, is that we hear about all these horrible crashes around the country, and sometimes the driver is prosecuted, sometimes they're not. And how is that decision made? Everybody wants to understand that. If you've ever been involved in a crash, you probably scratch your head trying to figure out your way around the criminal justice system as well. I'm a civil attorney. I sue bad drivers and companies to hold them accountable to my clients. The criminal justice system seeks to punish people when they commit crimes. It's there to protect the public, and we're going to talk about all this and explain more about how it works. So my guest today is Assistant District Attorney Dan McNeil. Dan is with the Mecklenburg County, North Carolina District Attorney's Office, and the reason that his title is Assistant District Attorney is that there is one elected district attorney and everyone else is an assistant. And he has been working at that office for a number of years. Now, we've got people joining from other states and other places in North Carolina. And your system, if you're in another place in North Carolina, your system is going to be a little bit different. And if you're in another state, it's probably going to be a lot different. But don't walk away, because we've got a lot of information that is going to be general and is going to be helpful to you in understanding the system where you live, or at least helping you navigate the information to understand that system. So one more thing before I bring Dan in, I'll have a few nuggets of information for you at the end that I want to talk about. So if hopefully you can stay throughout the whole presentation tonight, but if not, please check out the video and catch those nuggets at the end, because they're going to be important. All right, so without any further ado, I have Dan McNeil here. Hello, Dan. How are you?
Hey, Ann. Good to see you. Thank you for having me on.
Yeah, thank you so much for being here. You are a true public servant.
Am I good? My volume's good. You can hear me very well.
Yep, I can hear you great. I can hear you great.
Perfect.
Well, first of all, the fun part, you're not a stranger to the bike world, right? In fact, I think the last time I saw you was at a Bike Charlotte breakfast ride a few years ago.
I think that's right. And at the time I was on, for a long time, I was riding a single speed, right? I had a single speed like all the cool kids get. Super easy to ride, super easy to maintain. Great for me riding around town, going to lunch, going to wherever I was going to go. When COVID hit, I have 2 young girls and a wife, 8 and 5. And my single speed, I was pulling my 5-year-old who is not biking quite yet in the Bumblebee in the back. And as you can imagine, on a single speed, hitting the hills, hitting the big hills, my legs aren't built for it anymore. I just turned 40. I was dying at these times. So I had to, my road bike wasn't really the perfect bike for it. So I'm rocking one of the Linus. I think it's a 9-speed, basically a grocery getter. I'm getting around town with it, but I can pull my 5-year-old in it and not have sore legs for like a week afterwards. So I am a cyclist. I would never consider myself anything other than an amateur cyclist. I know some of my friends around town that I hang out with are some of Ann's, cycling buddies, but I would never ride with them unless it was a no drop kind of ride, because I am not in the same stratosphere as you guys. But I do love biking. I do support biking. And so I'm always pleased to see Ann and talk with her about cycling around the community.
Well, Dan, I will tell you that most of us are amateur cyclists, if not all of us, maybe everybody that's listening to this. Anyway, we got an angry face. I don't know if that was because of the single speed or the grocery getter. I'm not sure. Anyway, so we're here talking about the criminal justice system, of course, and tell us a little bit about your background. Why did you decide to become a prosecutor? Because you had to go to law school and all of that. What made you get out and say, hey, I want to, work for the public?
Absolutely. So I grew up, I was in a military family. My father was in the military. And actually my grandfather was in the military. My grandfather went to West Point, and he had 5 kids, one of whom was my mom. And my father worked for my grandfather in the Army, ended up meeting my mom that way. And then they had me, and then my father made a career out of the Army. And so throughout his life, and I spent a lot of time in Fayetteville, North Carolina, which is where Fort Bragg is the Army base there. And one of his things was always is that you need to serve your country in some way when you get done with whatever you're doing, whether it's undergraduate, whether or not it's graduate, law school, whatever you're thinking. And that can be in the Army, that could be as an assistant district attorney, that could be just someone that volunteers throughout their life. There are many ways to serve your community, but he always had this idea that you have to serve your community. And so when we grew up in Fayetteville, one of his best friends was Ed Granis, who was the longtime serving district attorney in Fayetteville. And his son and I grew up together. My dad was best friends with Ed. I was really good friends and best friends with his son. And I was, enamored with some of the court system. And I would watch, Ed actually had a court TV case at one point, and I was just glued to the TV watching his case. And he tried the case himself. As the elected, he tried the case, which is a rare thing, especially these days. Electeds aren't trying cases like that. And he tried the case. And I remember just talking with him so much about it. And that kind of sparked my interest early on, is that I love what he was doing. I love for him fighting for victims and fighting for victims that maybe don't have a voice in the criminal justice system. And I knew that's what I wanted to do. And so I went to Wake Forest for undergrad, and then ended up at Charleston for law school, and then came here when I graduated. And I've been at the district attorney's office here in Mecklenburg County ever since. And I think I'm right at maybe 12 or 13 years right now. So it's been a number of years.
You've seen a little bit of everything.
A little bit of everything. And I've been on numerous teams at the office, and I've seen now 3 elected district attorneys come in and out of the office. So, I've seen a bit, but throughout the entire process, something that's maintained is that fighting for victims, fighting for those that maybe don't have the same voices that some of us might have if we were, victims of a crime.
Okay. Well, let's start kind of at the beginning, because, there's a whole process, of course, as, for cyclists, if we find ourselves involved somehow in the criminal justice system. Sometimes cyclists get tickets. We'll talk about that a little bit later, but typically we're going to be victims of somebody else's, criminal driving behavior, I guess, for lack of a better phrase. So let's start at the beginning and talk about the law enforcement side of it, because that is what, that's usually already happened by the time you get it, right?
Absolutely.
Yeah.
And generally, so first we have to talk about Mecklenburg County in general, right? And so, when we think about Charlotte, we think about just Charlotte, and we have an elected district attorney that actually represents Mecklenburg County, as does our entire office. So that doesn't just encompass Charlotte. We're talking about Matthews, Mint Hill, Davidson, Cornelius, wildlife officers from the lake, Johnson and Wales officers, Davidson police, privatized officers that work at the light rail or maybe at the uptown areas. I mean, there's just so many agencies that are involved, and those are all cases that come to our office. And so anytime that we have a case, if it's a felony case, so we'll start with the felonies, the highest kind of cases. Felony cases are brought to our office through a papering process. So an individual's charged, they're brought before a magistrate when they're charged, and then those cases are brought to our office, and we evaluate every one of those cases that's come in when they're brought in as a felony. Misdemeanor cases can kind of go two different ways. If it's someone that is just being cited, they can be just handed a citation, and basically that's it. They're not getting arrested. They're not going before a magistrate. Other people can be arrested on misdemeanors, and they're brought before a magistrate where a magistrate determines probable cause at that time. So I know that's kind of a little bit hanky as to how they all come through, but that's generally how it comes through. And so when we talk about our office and what kind of caseload we're looking at when we talk about felonies, misdemeanor citations, we generally have 200,000 misdemeanors come through our office every year. 200,000. I mean, that's a huge amount. And then
I'm trying to do the math. I'm trying to do the math to figure out, per day or per. I guess some of them show up again and again, but.
Well, no, I mean, yeah, I mean, that's how many are new cases through a year, 200,000, right? Wow. And many of them come over and over. And then we generally have around 10,000 felonies brought to our office every year. So we'll talk first about the misdemeanors, because obviously that's the big number there, right? So
can I back you up even a little bit further, though,
sure,
before we even get to that? So law enforcement, how are police officers trained? I mean, because we all know a bicycle is considered a vehicle when it's being ridden on the roadway, but how are police officers trained on kind of the nitty gritty of the laws that they apply to bicyclists? Because I've had cops call me and say, well, what do I do when the bicyclist is in the bike lane and the driver right hooks them? I mean, what kind of training do they get?
Absolutely. And so when we talk about, bicycles as vehicles, and a lot of times those all fall under the Chapter 20 offenses of the North Carolina General Statutes. And the North Carolina General Statutes are the statutes that govern North Carolina law. I wish I'm at home right now. I wish I had brought my Chapter 20 offense book, but it's roughly this wide, and it includes all of the statutes. Some of them have relevant case law that's with them, and then some of them just have notes that go with every statute. And then you have the entire book of criminal offenses that goes with that. So it's a book that's about similarly sized. And so it's two giant books. And I'm a legally trained attorney who does this work full time, and I've been doing it for 12 or 13 years. And that book is immense. I mean, I read it all the time, and I'm flipping through pages all the time. But you can imagine an officer that maybe is going through basic law enforcement training, and they're trying to hit all of the major crimes that someone will encounter while they're a police officer. And so the major crimes are going to be like driving while impaired cases. It's going to be speeding cases. It's going to be initial calls to domestic violence cases. And then they're going to start jumping up to, assaults, breaking and enterings, violent crimes where they're called out to a scene, all the way up to homicides. And so when we talk about, how much are they trained in bicycling cases, or cases where pedestrians are involved, or just cases where two vehicles are involved in an accident? Generally, it's a lot of those times it's take a report, mark what they can on their reports, maybe get some statements, get witnesses, names and numbers. But a lot of times it's they don't have the time or the resources to spend an entire day investigating a crime that's just maybe a minor fender bender, or maybe an accident where it doesn't look like anyone's hurt, but then later on down the line, you realize someone's maybe hurt more than they seemed, or than it seems. And so those are cases that, sometimes it's harder to put them together from the end than it is the beginning. But at the beginning, they maybe don't have the resources or the time to do that. And many of them aren't going to be trained in specifically accident reconstruction. So we have an entire CMPD unit that is trained in reconstruction. They can do numerous formulas, numerous graphs, drawings, a lot of things that maybe can put a very, very clearer picture of what happened in an accident together. And they're excellent. They do. I mean, when I get one of their cases, it's in a binder, statements everywhere, graphs, pictures, numbers that go together that shows maybe speeds that they estimate, things like that. But when you talk about, patrol officers that are going out to a scene, they're going to do as best they can. They're going to do great work, but they're limited to what they know and how they can do it. So they're probably not trained to do some of these formulas or do some of these reconstructions, because if you were to enter that at a trial, we would have to tender them as an expert. And some of these patrol officers don't have the training and or experience to be the court that we believe the court would find them to be an expert. And so that's where it gets really hard, is that someone could be seriously injured and we have a limited case file that we have to work on, if that makes sense.
Yeah. And you mentioned that this, Charlotte's a pretty big city. So CMPD is the Charlotte Mecklenburg Police Department. They have their own reconstruction unit. But for other places in the state that don't have those types of resources, the Highway Patrol has a reconstruction unit as well. And in some states, it's called a major crash investigation unit, something like that. So how do you decide, or how does the police entity, whoever's investigating the crash, how do they decide whether they're going to call this special unit to come investigate?
Well, and right now, obviously, everywhere is stretched for just people that are out there in general. I know the Highway Patrol is generally have 1 to 2 officers that are patrolling a specific area, and so that's a good point on who's going to come out there. And if they're already on a crash scene or they're already working one crash, they might not have the ability to send someone else out there to a secondary crash if they only have one person working the area or 2 people, or they're going to call someone from a different county that might take 30 to 45 minutes to get there. And at that point, have we lost evidence? Is everyone, our witnesses, still on scene? Those types of things come into play. And they do a great job when they get out there and they're able to shut down the road and try to put it together. But certainly the staffing right now, and just generally, it is a tough thing to figure out if someone's on call that does have that expertise that can come out. Now, CMPD, they always have someone on call that's ready to come out to any of those accidents. But when you wake up in the morning and you hit Twitter, you might see 3 or 4 accidents on I-85, I-77, 485, and you have to wonder how many of those places are having an expert getting called out to them. And if one's already out there at one location, do they have someone that's going out to the second location, or is someone on call to go to the second location? Or if it doesn't appear anyone's that injured, are they sending someone out there to look at those types of cases? And so sometimes that's where, there can be an issue is if someone isn't necessarily showing signs of injury, or it's impossible to determine right then and there who's at fault, or maybe is there even someone that they could charge, they might not call someone out there, or maybe someone won't be called out there at the time. And then down the line, maybe there's someone that has a camera in their car that caught a lot of the action, or a real-time crime video that they had that they could see the accident. And then again, we're going back. Can we reverse it, and can we go back to the beginning and start anew? And that's when it gets tough. But anytime the police, put the resources to it, they sometimes make really good cases, even coming in at the end. But it does take a lot of work to get that starting point if they didn't start there from the beginning.
So I have a great question here from our Bike Walk NC, which is our statewide bicycle advocacy organization, which I always make a plug for. And when you hear the rest of this presentation, y'all are going to really need to join Bike Walk NC. But the question from Terry Lansdell is let me give this a little context. So obviously, if you have a case where, the driver says, I had the green light, the bicyclist says, no, I had the green light, and nobody else sees it, and, there's not really much of an injury, you're not going to do a police investigation, and it's going to be, he said, and that's the end of it. But there are some cases where you just think, well, you don't really need a witness because it's really obvious. If the driver just drives straight into the back of the bicyclist, or what Terry's asking is when a driver admits not seeing a cyclist riding with traffic, is that not an admission of guilt for distracted driving? How do you educate law enforcement to recognize blame of drivers over victims? Loaded question.
It actually is a great question and something we deal with. And so it is a good question. And so it kind of goes back to when I'm talking about our misdemeanor team, and I do supervise our misdemeanor team. And so when we start talking about 200,000 cases a year coming through our doors for our misdemeanor team, and pre-COVID, and this is kind of going into some of the office structure, pre-COVID, the misdemeanor team is generally the biggest team in our office. We have anywhere from about 15 to 18 attorneys, district attorneys, that are handling misdemeanor cases. And we could have 3 to 4 trial courtrooms running every single day. We could have a first appearance courtroom for anyone that's been arrested. We're doing first appearances for them in front of a judge. And then we have this courtroom, and we call it 1130 because that's the name of the room. And it looks like a miniaturized Belk theater is the best way I can describe it. It's this room. It's stadium seating. And on any given day, Monday through Friday at the Mecklenburg County Courthouse, we have probably anywhere from 300 to 500 misdemeanor cases come through the doors every day. They've either been continued or this is the first time they're on. And so when you talk about a case where a distracted driver might have rear-ended or rear-ended a cyclist, and a police officer comes on scene, he sees an accident, right? And so he writes an accident report, and maybe he writes the driver for failure to reduce speed, failure to reduce speed. And that's a common charge we see. It's an infraction, so it's technically a class 3 misdemeanor. It's a fine-only offense. And that's what he charges him, because that kind of fits the statute as to what has occurred. So a driver didn't see someone, and if you're treating this cyclist in front of you like a car, that's basically what it is. You fail to see the driver in front of you. You didn't slow down. You rear-ended them. There's minor property damage, possibly slight injury. And so when we see one of those cases, generally what we're looking for is an insurance letter stating claims have been taken care of on behalf of the driver who hit the other, either cyclist, driver, whoever. And that's about what we have time for in a courtroom that stacked and that big, right? I mean, that's what we're looking for. We're looking to see, okay, the victim has been likely made whole with their out-of-pocket expenses. Everything seems to be fine. Now, when you have a more serious injury, certainly that's where things start to get a little bit more hairy. But generally, we don't necessarily maybe see that in the charge, because all we're getting is an infraction piece of paper where it kind of says what happened, where it occurred, maybe a little bit of a blurb about what happened. But beyond that, there's not much on there. So we're not hearing from the victim beforehand because it's an infraction. It's not under the Victim Rights Act. So maybe we don't hear that from them. And so we have to make a snap judgment call when we've got about 30 seconds to make a call, and we've got 200 other cases that are just waiting in line behind them. And at the end of the day, like we said, if we go to trial on something like that, we've got a driver saying, oh, I didn't see him. Sorry. I just didn't know that was going to happen. We may or may not have our victim there. And especially if our victim has been paid, a lot of times, their insurance has been covered. They don't show up for court because they're whole now. And so putting that into a trial court where we're trying, I wouldn't say more serious cases, but we're trying driving while impaired cases. We're trying domestic violence cases. We're trying carrying concealed gun cases. We have to weigh, is this a case that's going to take up court time versus some of the others? And sometimes it is. Sometimes we're willing to put those up there and say, you know what, it's still a class 3. I know it's not going to do anything to them but be $100 fine. But we think this person should pay this $100 fine because that's what it means to the victim. That's what it means to us who's supporting the victim. But yeah, that's tough. And when patrol officers get out there, or not just patrol officers, any type of officers get out there and they talk to two parties, and both parties, if that person doesn't say, oh, I didn't see him, you just have a person saying, oh, this person stopped, I didn't see him. And the other person saying, yeah, they hit me. it's a he said, or a she said, and that makes it pretty tough. Sometimes a judge is going to find a tie goes to the runner, and the runner might be the defendant in this case. So that's where it gets to be quite a difficult process into how we evaluate a case that is willing to go up to a trial court and be tried. So any case that comes into 1130, there's no judge in there. It's just the DA, and it's just the defendant or the defendant's attorney. And we're negotiating offers that keep a case from going to trial. If every 300 people that come through 1130 say, I wasn't speeding, or I didn't do this, I want this to go to trial, the court system would come to a screeching halt. We would not have the time to do anything. So, when we're dealing with hundreds of speeding tickets every day, we're trying to negotiate pleas based on parameters that our office has that say, okay, you were speeding this day, you can plead to this. It might affect your license, it might affect your insurance, but we'll reduce it down by this much. And so that's stuff that we have to make basically snap judgment calls on every day. My team's doing it, and they're good at it, but obviously it's a tough call when you're having very little time to make a decision on. And you and I know when you're in law school, you get a test question, and you spend 30 minutes to 3 hours writing out well, maybe this could happen, but if this happened, this. They're getting newly out of law school a 30-second question and saying, hey, go ahead and figure this out really fast. And so it's a tough world they live in.
Right. It sounds very chaotic. So here's, and I think this is the same in I know it's the same in every county in North Carolina, pretty much. And it's probably the same. It has been the same in other states where I've seen it. And I imagine it's just the same everywhere, because nobody ever allocates enough resources to their public systems. But here's a question that really can be the answer that can be helpful to everyone, which is, what do we do? Like, what if suppose you're a bicyclist, and because it sounds like you don't even know if the ticket relates to a bicycling crash. You just know that the driver did something. So if you're a bicyclist who suppose, the driver is going to court with an insurance letter, but you also know that their insurance doesn't come close to covering your damages. Or suppose that you're a bicyclist who has, where the driver wasn't charged, but you think there's some pretty obvious evidence. Maybe you had a video camera, or maybe, the driver made some admission or something like that to the police officer. What can you do? Do they contact the police officer, contact your office? Give us some options.
That's a great point. And one, I guess we should have said this at the beginning. I can't, in no way an Ann or I guess me personally, I'm not giving legal advice in any sense of this conversation. And I'm telling you some general parameters. So I can't promise anything or tell you what will happen if you were charged in Mecklenburg County.
Fair enough.
But certainly one thing is that when a civil attorney does get involved, many times they contact our office and they say, hey, this seems a little hanky. Someone was hit, no one was charged. Does this seem normal? Does this seem within the parameters of what normally occurs in the system? And if it seems strange, I can always, or someone at my office sometimes will reach out to the officer and say, hey, tell us what's going on here. Is this what's going to happen? Is this right? At the end of the day, our office is not the charging agency. So we're never the ones that bring charges against someone. So that always relies on the investigating agency, whether or not it's CMPD, Matthews Police Department, Davidson, Mint Hill, wherever. They're the ones that bring forward the charges. But there's also a secondary kind of avenue, and people can seek a criminal summons against someone going to the magistrate's office, or even going to the magistrate's office to explain what occurred. And sometimes the magistrate's office might give them some guidance as to what kind of charges that they're looking at, or maybe they could bring charges against this person.
Have you seen that work with success, where somebody goes on a driving job? I'm just curious, because I know some people have tried it in other counties with, I think, varying success, but I'm curious.
We see it pretty regularly with what I would say are road rage incidents.
Okay.
I think that's a common thing we do see. And we actually have a courtroom devoted to private warrants, which are magistrate initiated cases.
I see.
And we do handle those. We sometimes, in those cases, we have a mediator present. So they might go through a mediation process before they go to a trial, or before we find if there's a plea offer, before we find something that a class they might attend that might see a different resolution. But there's a mediator there that we can always say, hey, I know that you guys have your issues out there. Go talk to this mediator. And if something works out, great. If not, we'll kind of reevaluate once you go there. And so I know in plenty of road rage cases, we have seen magistrate initiated processes that then come to our courtrooms.
Okay.
Those are sad to see. I mean, honestly, because, you have to get to a bad place where you're going to, one, get to a road rage incident. And, I know that most cyclists have been involved in many, or maybe not many. They've been involved in one here and there, probably because there are people out there that just for some reason hate cyclists, and they're going to do something that seems egregious to a party. And at that point, when a magistrate says there's probable cause, we're at least going to look at these cases and say, yeah, let's see what we can do. And either one, figure out what went wrong that day. Maybe that person was having a bad day, or maybe they just need to go to a class for their anger management, or two, go through this mediator and try to talk it out, or three, maybe they do need to go to trial. Maybe we need to seek a criminal conviction against them.
That was such a perfect answer, because the last two questions that I got here from listeners were about motorist harassment of bicyclists. And they were wondering, is it a crime for a motorist to harass a bicyclist? And I guess what kind of crime is it? I mean, how do you, and it sounds like they could go, if they can't get the police to take out a charge, they could go to the magistrate's office. But what kind of things would constitute harassment, or a harassment that would amount to a crime?
Sure. And things that I personally have seen through the years, one would be an assault charge, where a cyclist and a driver have an issue. Maybe the driver turns their car towards them, or, does the swerve move where they pull in front of them. And I think with that, generally assaults are, you have to have that intent. But when someone's clearly swerving a car at you, I think there's an assault issue there. And sometimes I've seen them charge assault with a deadly weapon. Now that still falls under the misdemeanor purview. So it's still a misdemeanor, which some people might say like, well, that seems so dangerous, it should be a felony. It is, but it still falls under the assault with a deadly weapon purview, typically, of what I've seen. A simple assault for sure. I've seen communicating threats charged with drivers and other drivers and cyclists, where someone says like, you keep tailgating me and I'm going to get out of this car and, whoop you, but something maybe more illustrative than that. But I'm not sure. I'm trying to think if I've ever seen a reckless driving charge based on a magistrate's initiated processes. Maybe, but it's been, it might be a while since someone's charged with a reckless driving. And a reckless driving would fit, especially because it says basically if someone drives where another person or property are put in great harm's way, that constitutes reckless driving. But again, I know the cyclist community out there is thinking like, well, reckless driving, what's that? And yeah, it's a class 2 misdemeanor. It's not, it's not the worst of charges, but it certainly might get someone's attention in the end, that maybe their actions should be curtailed or brought back a little bit once they got that charge.
Yeah, that's interesting. Yeah, that's really interesting to hear that you've seen a lot of these go through the system. Be interested to hear from our listeners whether anyone else has tried that in other counties and what your success rate was. Okay, let's see. Well, we talked a lot about this, traffic charges and the traffic court 1130. Let's talk about, you started talking about felony charges, and let's talk about more egregious driving behavior and more serious injuries. First, let's start with more serious injuries. Okay, so here's a huge frustration, right? When people are seriously injured and the driver's charged with, an infraction, running a red light or whatever.
Reckless driving, right? Reckless driving too,
Yeah, been those couple of articles out lately on that where, a person's life is ruined because somebody screwed up, they weren't paying attention. And but there was no drunk driving, no intentional buzzing or anything like that. They just did something stupid. So what
And
happened?
I mean, it's difficult, and that's that's the hardest cases that, well, maybe not the hardest cases. That's an incredibly difficult number of cases that I may see with a cyclist, and where someone's terribly injured, but it's not a drunk driver, maybe not even a distracted driver, maybe someone that has, lost attention for a second or two, or veered and they weren't paying attention, or were speeding. Maybe they were speeding, but maybe it's 10 miles over the speed limit and they're in a 55, well, probably not 55 with the cycle. Maybe they're in a 35 and they're going 45. And what kind of charges might you see? And honestly, I'm not sure there's a lot of charges in North Carolina, and maybe not across the country, that really fit the bill for if a cyclist is not gravely injured, is seriously injured, but there's not impairment. There's not actions by the driver that rise to a level of, this is so egregious, anyone would have known that this would have likely have caused great bodily harm to another human being. And so the fallback is, I mean, it's going back to the misdemeanor. It's going back to reckless driving. It's going back to maybe failure to decrease speed. And that's tough, especially when you're talking to a victim who maybe has broken bones, maybe has a concussion, maybe has an injury that might prevent them from getting back on their bike for quite a while, if not for a long time. And those are tough cases. They're incredibly tough. And a lot of times, even if you do proceed on like a reckless driving charge, restitution is likely not going to ever meet whatever they're likely to suffer with their medical bills. The criminal justice system generally isn't equipped to have someone pay someone medical bills for a longevity period, or for an entire lifetime, or even just over, $100,000. Those are things that are we as the criminal courts rely on the civil courts to possibly seek those damages. But I know personally that sometimes the civil courts aren't equipped for that either, because there's various other reasons that come into play, but that's tough. But yeah, when you sit there and talk to a victim who's been seriously injured by a driver, and it doesn't rise to the level of a felony, and North Carolina doesn't have statutes that allow for us to charge a felony, we're back to a misdemeanor. And what's that mean for a victim? Nothing. I mean, really, they might get put on, a type of driving probation, or they might have to pay some fines, or they might have to do community service. But at the end of the day, that's not going to make them whole again. And that's a hard thing to tell someone when we talk about driving that maybe doesn't rise to the super egregious level, but it is worse than just regular driving, I guess. And they're not killed.
Well, in North Carolina, we have sort of a very weak, I guess, or just not very, what am I trying to say? That punishments aren't very severe on our vulnerable user law. Which, I think it's an increased fine or something. It's a very limited driving behavior that triggers it. So, but others.
And I guess we should say, in North Carolina, it does have what we call a sentencing chart, right? So even with misdemeanors and with felonies, judges have to sentence within certain parameters. And this goes through all the cases, not just ones we're talking about. But if someone were to be charged with a robbery case, and that's a Class D felony, and they're a prior record level 1, they have certain boxes that they have to remain in. So the judge can't say, this robbery was so egregious that I'm going to sentence you to 50 years. That's been taken out of the judge's hands for great reasons, because we're trying to be equal across the board when we look at defendants and people charged. But it does limit what judges can do at times. They have to stay within these parameters as to how they can sentence. And so that's something that they always have to consider. And that's something we have to consider when we're looking at what types of offers we have to make in a case.
Terry brings up an interesting point that he said, got to follow up on the 10 miles an hour or over comment. We have to help officers understand that 10 over is drastically different at lower speeds, i.e. 10 over 35 versus 10 over 70.
And it's a great point. But one of the things we get back to is, if there's an accident involving a cyclist and we're 10 miles over the speed limit, we have an ACM, the module in the vehicle that might tell you what a car is going at 30 seconds, 2 minutes, 10 seconds, 5 seconds, all the way down to when impact happens, when the airbag deploys. And when a cyclist is hit, a lot of times that might not happen. And so our reconstructionists are putting together what they call a throw module. Like when someone's thrown from a bike and they're looking at how far they went, how far the car, all sorts of, I wish I could describe it. I don't know how to describe all the numbers, but they put together all of these equations that show likely what speed they think the vehicle was going. And I've had plenty of these cases. And I can assure you, when a defense expert is then hired to look at that same number, look at the same feet, look at whatever they're going to do, their number is going to be different and beneficial to the defense. And so when you think about trying that case in front of a jury of 12, and those 12 people, you've walked out onto Tryon and Trade Street and you've just said, you 12, come with me, come to an agreement on what's occurred in this matter. And you've got one person who's an expert saying one thing and one person who's an expert saying another thing. It makes it a difficult decision for a jury. And that's not to say that my office or I won't go to bat and say, you know what, we believe in our expert and we believe this case is strong enough. But obviously it makes it difficult when you have two competing experts saying two different things. And Ann, I know you know that with the civil world, that everyone has experts that they have on speed dial and they're going to show them the information. I'm not saying they're going to fudge anything, but you're going to have people that you trust their math better than the other person's, and you're going to hire those people. And so that's what we deal with a lot, especially with cases like this.
Right. And it comes down to, I imagine, a resource decision again. I mean, there's only so many hours in a day and so many people in your office. And
That's exactly right. And my office is staffed with 85 district attorneys. So Spencer Merriweather, our elected district attorney, we have 85 district attorneys and we have 55 members of our support staff. For an office of our size in a similarly situated city, a lot of cities have over 120, if not closer to like maybe 140. So you can imagine at 85, what types of caseloads Mecklenburg County is seeing that we think we should have, maybe if not double, at least, a half double of what we have. And so, yeah, we never say that we're limited in terms of evaluating a case or being willing to go to bat for a victim. But certainly it stretches us when we're trying to try so many cases or try to bring justice in so many cases. And it certainly is something we have to consider when we're looking at if this case could be a plea and we could see something, or if it would go to trial and be a 2-week trial, what we're going to see. But, we're going to take cases to trial that we think are winnable cases and we think need to go to trial to see an action against the defendant.
And this might seem like stating the obvious, but to kind of make a point here, you can only work with what you have in terms of, what the law says. You mentioned that before in terms of sentencing, but even in terms of what you can charge, what charges you can bring, I mean, that's really up to the legislature. And so if we have someone to complain to, it ought to be our legislators.
Yeah, absolutely. And we always have to work with what evidence we have. And certainly that, I don't want to jump ahead to like what felony cases we might see, but Ann, you and I, the first time we met was on a case, and that's how we kind of jump ahead. Okay. Yeah. I didn't want to jump ahead. But yes, the first time we met was on a case. And at the time, I was on the violent crimes team. So our office has numerous teams within it. There's a misdemeanor team. There's a felony crimes team. There's a habitual felon team. There is a violent crimes team. There's a juvenile team, special victims, homicide. And so these are all the teams that are within our office. And at the time I was on the violent crimes team. And because I'd tried so many driving while impaired cases, I became our de facto vehicular prosecutor for people that were injured, but survived their injuries. And so I'll tell you the story I didn't want to research it before we got on the call because I didn't want anyone that's on the call to know what case we were talking about. It's a closed case, so I can freely talk about it. But in case, the victim in the case is listening or anyone knew him, I didn't want to talk specifically about his case. But I had a case come across my desk, and there was a group of individuals out cycling. They were in a peloton, they were in a pack, and they were up, I think, in the University City or Davidson, like a very common bicycling area. And someone was behind them on a 2-lane road with double yellow lines. And I think he was driving erratically, going back and forth, kind of honking, basically wanting to get around them. They were going at what I would probably consider as a good clip because they were all excellent cyclists. So nothing that would make you think like, oh, they're just blocking traffic or doing whatever. Well, the truck goes to go around these individuals. He doesn't know that they're all slowing down to take a left turn. So most of the pack has gotten to the left turn, and he clips one bicyclist, nearly clips about 5 or 6 others, but gets one guy good and puts him into a ditch. Just, I mean, the scariest you can imagine if you're on a bike and you're riding, to get hit from behind by somebody. Some of the people stop with the injured party, which is, obviously what you should do. But then some people take off after the driver, which I would never recommend doing. I can't say that's the smartest thing to do, but God bless them for going after him. And they took off after him. And I thought, no way they would ever catch this guy. But he pulls into a road. It's a dead end. And they basically corner him into a dead end and say, like, dude, you hit somebody back there. You drove off. Like, are you serious? Like, what are you doing? I think it might even be mid-morning. Police arrive on scene. They start talking to this guy and realize that I think he's impaired at the time. I think he'd been drinking or had been drinking the night before, still had a blood alcohol concentration. And so this case comes to me, and that's basically the case that I have when it comes to my desk. And I think, like, this is a pretty strong case. Like, I mean, I don't know if there's any real issues, but I like the case. I like the charges that are being sought. I think this is a triable case. If not, we can offer a plea as charged kind of deal because I'm confident in this case. And Ann contacted me and said, hey, I'm representing the victim in this case. Let me know if you need anything. I would love to help out in any way possible. And I said, always it'd be fun to have, like, interviews from all the witnesses and, maybe the speed of the bicyclist, because this guy was saying they were going too slow. And, it'd be super cool to have like a video of the accident, but what are we going to do? And Ann said, yeah, I've got all that. Just let me know when you want it. And I was like, wait, what? And she's like, yeah, everyone in the cycling community has that gearhead friend that, has the GoPro and he films everything. Everyone's got the GPS on their bikes. They know how fast they're going, what their distances are. And everyone gave Ann their contact information because they felt so passionately about, someone hit our friend. We're not going to let this person get by. And so this case went from being like a pretty good case to like an exceptional case. And in the end, it worked out, I think, as best it could have with the evidence as we had it. But those are the types of things. If you're a victim of a cycling accident, those are the types of things that help the investigation. And sometimes police officers might not know all that's available to them, especially when you're talking about the bike GPSs or maybe a GoPro that they don't see at the time. But those things became such an important part of us being able to say, we don't really want to offer anything because this case is so strong. And we think someone driving drunk or someone hitting people and driving off is such an egregious activity. There's no reason to make an offer that seems to be less than what it really is.
That's great. So that kind of segues into, a question that one of our listeners posted about video and whether video is helpful to you in prosecuting a case. You're laughing because the story you told kind of answers the question, but maybe you could talk about that a little bit. And a lot more people are riding with videos these days.
Absolutely. And I mean, if you have the ability, I would always recommend it. And so many drivers are driving with videos, and there's so many videos at businesses that now face out to the road. And so the number of videos now involved in criminal cases, it's almost to the point that jurors expect there to be video from every single crime. And when there's not, they're like, how can no one be filming? Or how could there not be a video from this business? Or how could this not be the case? But yeah, I mean, it is the most, I mean, a witness statement from the night of is good. A witness statement from a week later is not as good. A witness statement from 2 weeks later might be kind of shaky. But when you can put a video up of the incident or any type of incident, or even talking to witnesses and recording them immediately after. So maybe the video doesn't capture the incident, but if it captures what people are saying immediately after and they all corroborate the story of what happened, that's as strong as it gets, because all these people can say, yes, that's what I saw. This is the video that recorded what I said that night. This is exactly what happened. And so I mean, videos have obviously changed the game in a lot of the criminal and civil world in terms of trying cases. I mean, it's just so persuasive when you see it on video and you can have someone articulate what exactly happened.
I was smiling because we have a comment from the cyclist who chased down the driver that you were talking about.
Thank you.
Yeah, I'm sure you appreciate that, again, with your limited resources that are allocated to you, you appreciate the help. And I mean, what other ways can you talk about what other ways bicyclists can help when, when there's a some kind of charge or case or, whatever evidence can be gathered?
Sure. And I mean, one is, and this is no way blaming the victim type of thing, but one would be always abide by the rules of cycling within the North Carolina general statutes as well as Charlotte. So if you're riding at night, obviously having the correct lighting on your bike, wearing a helmet. I mean, obviously that's not for, I don't think it's required, but having a helmet should be everyone's, deal. Riding in the right-hand lane, not in the left-hand lane, hand signaling when it's time. Those types of things, I know they sound ridiculous, and it's like, well, everyone does that, but it's like those types of things when a criminal case occurs and some defense attorney says, well, they didn't have the lights on the back of their bike. I don't know if this is the perfect case. It still doesn't negate our case, but certainly we still have to think about 12 jurors hearing this evidence. And what if someone says, well, I've been out before and I've seen someone not have a light on the back of their bike, and that really irks me. And so that becomes an issue. But I think, obviously, if you have a recording, that's perfect. If you have GPS, that's great. If you have the ability to record afterwards, that's great. If you have the ability to record or at least take a picture of someone that's hit you so that, even if you have a license plate number, that's great. But we still need to see. Oh, am I breaking up a little bit? Am I good?
You just for a minute you did, but you're good. You're good now.
Yes. So, even if you have a license plate number, getting a picture of a driver is way more effective, or having a picture of them getting out of the driver's seat if there's multiple people in the vehicle, being able to give a description of the vehicle if it does leave, or a description of the driver if it does leave. These are all things, I mean, the smallest of details, and it really helps if you have, I would say, keep a notepad maybe in your, your flat kit. If you have just a little tiny notepad that you can write anything down that might come to mind, or if you record all the things you're thinking of, if you've been a victim or you see someone that's been a victim of an accident, to say, these are the things I observed. This is this date, this time, this is where it occurred. Any detail is going to be able to help to say to any officer that comes, here's all the things I remembered, here's all the things I have. And they're going to take that information from you and make it part of their court file. So it becomes a more voluminous and a more illustrative court case that we can prosecute at the district attorney's office.
There's so many things.
I know it's so much.
I know there's so much. And I'm sure you have so many stories that really could be helpful to people, but let's just touch on the serious case. Okay. So there's a fatality or serious lifelong impairing injuries. And, the most serious charge that we often see, not always, but often see, is misdemeanor death by motor vehicle, which, often doesn't even end up in a jail sentence unless there's a significant prior record. So just talk a little bit about what people can expect if they're the victim in one of these cases.
Yeah, and unfortunately for me, I generally screen and meet with any family who's had a loved one had a loved one who's decedent, or a family member has been a victim of a misdemeanor death. So I spend a lot of time meeting with families of those types of cases, and I think Vision Zero had us at over 100% increase in the past decade for fatalities involving pedestrians, accidents, bicyclists. So the number of cases have gone through the roof.
Totally where we want to be going. Yeah.
Right. And part of this, certainly Charlotte has seen an increase in population, which is an increase in drivers. But I think at the same token, I think there's a decrease in people, I don't know, respecting the speed limits, respecting driving just generally. And it kind of comes together in a terrible, terrible number. So the North Carolina legislature did create this statute that basically makes any case in which there's been a vehicular accident where someone dies a misdemeanor, and it's a misdemeanor death by a motor vehicle. Now, it is the highest class misdemeanor, but obviously it's still a misdemeanor. And every time I sit down with a family who's lost a loved one and I explain to them it's a misdemeanor, it's a tough conversation. They don't teach this in first year law school, second year law school, third year law school. It's something I've had to learn through a number of years of meeting with families. And I normally start out by saying, listen, everything I'm going to tell you sucks. It's the worst of the worst. That's not a legal term. It's not a Latin term. It just sucks. And we're going to get through it. But I guarantee you at the end of the day, whatever justice is doled out likely won't be what you think it should be. And I have plenty of family members that I talk to and say, what do you think justice is in this case? And they'll say, well, I think this defendant should be in jail for every day that I wake up and don't have my loved one next to me or downstairs or have them on the phone with me. And I say, I can't disagree with you. I mean, I think that's a fair way to feel, but that's not what the law intends, and that's not what the law allows. And so having this charge makes it difficult. It certainly makes it difficult with these types of cases because it basically allows for any type of traffic infraction or traffic accident for that to be the main charge. And that's the charge that fits under the statute. It would require something extremely egregious, something that almost shocks the conscience to get it out of that realm without impaired driving or without drug impaired or alcohol impaired driving. And so when we talk about those types of cases, they're difficult and they're really hard. In many of those cases, unfortunately, what I also see is that I have to prove a proximate cause in those cases. And sometimes there's multiple proximate causes, and that's where it gets extremely difficult. And you might have a cyclist who isn't using lights at night, or who is slowing down for a red light, but realizes there's no cars coming from the direction in which traffic should be coming. And then someone else is coming from a different light that also runs that light. So you've got two people running a red light. Unfortunately, one's on a bicycle and obviously is going to take the brunt of that. So multiple proximate causes also become a major issue in these cases. And then you also just get people who have no criminal history, have no driving history, have never been in the court system at all. And they made a terrible mistake that day and they hit someone. They didn't slow down in time. Traffic backed up near IKEA or some other place on I-77 that you're not expecting it. They rear end someone, and not a cyclist in this situation, but rear end someone in a vehicle and someone dies in the other vehicle. These cases are impossible. I mean, they're so hard to do, and they're what I spend a lot of sleepless nights thinking about because they're so hard to explain to families why this is a charge. In some states, they don't have this charge, and so police officers can tell them there's no charge that's going to be sought because there's nothing that fits the bill. And here we have a criminal charge, and then people say, well, you have a criminal charge, but why isn't it something even worse? And many times I have to say, like, I don't know. I mean, I think there are some situations that maybe warrant worse charges, but these ones maybe don't do it because it's a simple accident that everyone can be involved in and someone doesn't die every time. And so that's where it gets to be really hard with these cases. And, when I see the white bikes around town, the ghost bikes, and knowing that some of these cases are my cases that I've dealt with, and they're just so hard. And they're so hard when I talk to these families. I would never say that it's nowhere harder for me than these families, but I sit down with these families all the time and talk with them about, what's closure in this case? What's the right move to make in this case? What's going to make you feel better? What if the defendant doesn't speak at the sentencing? What if they want to address you? What if you don't want to be part of the criminal process? And these are all things I've dealt with in these types of cases. And there's never a right answer. And that's what I always tell families is that I don't know what the right answer is because I'm not in your shoes. And I just unfortunately don't know. And I don't think it's going to fit the bill as to what justice is, but maybe it fits the bill as to some families can find closure in it, and then some don't. And it's going to be something that eats at them. Or sometimes it is the criminal case might find closure for you, but the civil case might find what you're looking for in terms of hearing from someone or hearing more about the case. Because in the criminal case, no one ever has to speak. And even in a sentencing, they don't have to talk about it. And you hope that they do, but they're never going to speak. And then once that criminal case is done, maybe they're more open during the civil case where they can speak a little more freely. But I know that's kind of a rambling answer as to how we get there, but they're impossible. They're so hard. And yeah, I mean, when someone dies as a misdemeanor, the right piece to the puzzle. I mean, I doubt it, but that's what the legislature's intended, and that's not for me to judge or to determine something different. So I don't have the ability to change the law or make something different or make a sentence worse, because we're still in that grid of we have to stay within the grid in terms of a sentence.
Well, what are some things you mentioned, some more serious behavior that would warrant a felony or higher level charge? What are some of those things? What have you seen examples of?
I mean, I've seen people in a certainly impaired driving, and I think we covered that, but people that are on or someone that might be on fleeing from the police and T-bone someone or hit a pedestrian or hit a cyclist while fleeing from police. So they're already committing a felony, and then they end up killing someone. Driving 30 miles an hour might get there. Having past histories of medical episodes where you might be prone to falling asleep or blacking out or having some type of issue, and it occurs again and someone dies. Those are ones, and that's where we kind of get into what we call 404B evidence, maybe, where 404B is prior bad acts or prior bad history that might relate to it. Or you've got 15 speeding tickets in a year and you're speeding again, and then hit and kill someone. And I don't know the facts of this case, but two cars racing, I think it's a recent county nearby, had two cars racing and hit someone. Those are the types of things where you start to see serious charges where, I mean, those are types of underlying issues that I would say the average person says, that is crazy. No one should be doing that. That's disgusting. I'm disgusted by it. But beyond that, sometimes it gets a lot harder when you're talking about less egregious types of driving acts.
And when we start to talk about why we are kind of getting into law school territory, but it has to do with mental state, right? Basically, I mean,
Absolutely.
you have to
And
be able to prove the mental state beyond a reasonable doubt to a jury. So that's your hurdle.
yes, and that's a good point. And so when I sit down with a lot of families and they say, well, why aren't they charged with assault with a deadly weapon with intent to kill? Because a car is clearly a deadly weapon, which I agree with. But I'm saying with the intent to kill. And so you have to have that mens rea, or the intent that you're going out there to maybe end someone's life. And that's where you have to get to that level of beyond just the intent, but to something that's so egregious. But yeah, I mean, those types of cases, unfortunately, we do see those as well. And we see people driving at high rates of speed that unfortunately take the lives of others. And those are difficult. And those are the super sad. And, I find them as sad as some of the gun cases throughout Charlotte, that it could be prevented. It didn't have to happen. And here we are with people just making super poor decisions and super bad decisions.
This is my last question before we kind of wrap up. What about texting and driving? Can that be
awful? And texting and I mean, how many times do you stop at a light and you see people on their phones, and then you see people and you see them starting back up and they're still on their phones? I mean, I think the studies say, and I wish I would have looked this up because it's a good question. I think they say texting while driving is equitable to impaired driving. It's similarly situated that your mind is not focused on the road. Your reaction time is decreased. These are things that just are so bad. And unfortunately, I think it's such a new niche of law that I don't know if we have a lot of case law on it, or we've seen a lot of trials to really gauge, and this is across the state, to gauge what the public might think of a charge like that, whether or not we see convictions and those types of things. But I think when you can have an expert that sits down and says, this is as dangerous as impaired driving, I think it kind of starts to rise to that level, right? Like it's going to say, every single person on the jury says, yeah, if you're texting and driving, you're no way focused on the road. I've done that before, and I forgotten that I was driving for 5 minutes, and then I looked up and I was still driving. It's like, yeah, that's the person that hit someone, the 9th time out of 10. And those are scary moments. So I certainly, for anyone with teenagers out there, please figure out a way to put them on the silent mode or the, can't text while they're driving mode. But we definitely, I mean, I've seen those charges throughout Charlotte. So I know police, when they see it, are stopping people, saying, this can't happen. This is going to be a much worse situation down the road. you need to figure this out. And so, and we see them come through court and we deal with them accordingly. So it's certainly something that's, yeah, that we typically, a lot of times we send those people, especially for people that are under 18 or under 25, we put them through a driving course, in-person driving course where they learn about the dangers of drunk driving, the dangers of texting while driving. They do actual driving modules while they're doing that kind of stuff, so they know how dangerous it is. So that's something that we want to see, and especially with these younger drivers, to make sure that we don't see worse drivers down the road. And so it's scary, and especially when you see it on, you're driving on 485 and you see someone with a knee on the wheel and they're just texting away, and you're like, come on, man, what are you doing? But yeah, so no, I think that's going to be something we see way more often, and maybe start to see some different cases on if there's worse scenarios that occur.
Yeah, and I imagine that it's a little bit different for you. I know it is for me in my cases when somebody is, maybe they look down at their phone because they hear a ding or something like that and they cause a crash, versus somebody who is just perpetually on the phone and you can show back-to-back phone calls and texts, and then they drive off into the shoulder and hit somebody.
That's exactly right.
I mean, you might be willing to prosecute that case for a higher level felony. Am I right? Or consider it.
I'm sure. I would never I don't make that call, obviously, because I do the misdemeanor cases. But certainly, our felony team might look at those and make a call based on the egregious nature of the case and what they're looking at in the case.
Yeah. Well, I really appreciate it, Dan. Thank you so much for your time. Was there anything that you really wanted to mention to our audience that we haven't gone over?
No, I think we covered a lot. I feel like we kind of ended on a sad note. I hope that everyone out there stays safe throughout the time, especially when it's getting dark outside. Please wear your lights. Please wear your helmets. I'm driving uptown every day and I'm seeing this new bike lane, I think going in on McDowell, right? It's a protected bike lane that looks pretty awesome. So I hope that people that ride uptown certainly can utilize it. And, as I drive around uptown on my bicycle as well, I see a lot of cyclists that are doing the right thing. And I just wish that everyone would follow those same rules, including the motor vehicles uptown as well. I know that is where it gets to be hairy, but certainly there's a lot of stuff going on uptown with the trains and the vehicles and the bikes. So I hope we can all get together and no one has any issues, but certainly it doesn't always work that way.
Well, I imagine this is one of the things I wanted to say at the end, that I knew this was going to be kind of a reality check for a lot of us, and hearing, the limits of the justice system and what it can do to promote justice. And so, I want to encourage people to join their local advocacy groups, and particularly their statewide advocacy groups. In North Carolina, it's Bike Walk NC, because if you're thinking, how can I possibly do anything about this? I don't have time to call my legislators or go down to the legislature or do all this stuff. There is somebody who is doing that for us on behalf of bicyclists, and that is Bike Walk NC in North Carolina. A lot of the states that we're in contact with have organizations like that, Bike Utah and Bike Maryland. And so please join those groups and get to know your police departments, right? That's helpful too, because then you have a contact. You're not just going there after something happens. You already have a contact with that police department and a friendly face to go to for help and ask questions. And the final thing that I want to say is, you heard about the criminal justice system not being able to provide a whole lot in the way of restitution, which totally makes sense, because you can't get blood out of a turnip. If somebody doesn't have money to pay, they don't have money to pay. And so there's also a lot of people driving around without insurance. And if you are seriously hurt as a bicyclist, the only way to be sure to be protected is to protect yourself. And that is to, in most states, underinsured motorist insurance, to protect yourself against uninsured drivers. I talk about this in practically every time I ever speak to anybody, because it's so important. If you have a car, you can get underinsured and uninsured motorists. That applies to you if you're hit by a car on your bike. So please get that. We've seen a couple of cases. A couple of people have come to us recently where it's a huge game changer, and somebody thanked me for advising them years ago because of the impact financially that their injury would have had on their family. So please take take those two pieces of advice and make this a better world. So that is the goal. Thank you so much, Dan, and thank you for those who were on here tonight. This has been super, super helpful, and everybody stay safe over the holidays and enjoy.
Thanks, Anne.
All right, take care. Thanks.